Now, impeached Nairobi Governor Mike Mbuvi Sonko has lost his bid to have the vetting of Deputy Governor nominee Anne Kananu by the County Assembly stopped. The courts have also blocked Sonko's attempt to stop current acting Governor Benson Mutura from appointing, reappointing or dismissing county officials. This forming just part of the barrage of petitions before the courts touching on the leadership of the capital, Nairobi County. For months now, the city has been on the spotlight with political machinations, sometimes veiled as legal contests, taking center stage. So on this episode of The Front Row, we'll be seeking to break down all these legal and political issues and what they portend for the larger political landscape. Thank you for joining us on The Front Row. I am Akisa Wandera. Welcome to the show, and of course, to be part of this conversation, do log on to slido.com. Event code is #TheFrontRow. You can as well speak to us on Twitter and the other social media platforms. The hashtag to use is The Front Row. Twitter's at Akisa Wandera, at KTN News KE. I'd love to hear some of your thoughts on some of the legal and political battles currently being witnessed in the capital city here in Nairobi. Let's take a look at who's helping us dissect these issues on this episode of The Front Row. George Kithi is the managing partner at Kithi and Company Advocates. His areas of practice include civil and criminal litigation, family company law, insurance law, commercial litigation, and intellectual property law. He'll be joining us tonight in his capacity as a lawyer, who's also handled a number of issues on Nairobi, and with his understanding of the city, he'll be helping us break down some of these issues. Second, we have Professor George Wajakoya, a lawyer also, and is a founding partner of Luchiri and Company Advocates. He has over 25 years experience in a wide range of cases and is currently a faculty member at the Institute of Migration at the University of Nairobi. Thank you for joining us. And finally, Javas Arafat Bigambo, who is a governance expert, is a consultant in governance, human rights, leadership and communication, is the founder of Interthoughts Consulting, and he studied political science, human resource development, communication and the law at various universities. He's also a former lecturer at the Moi University, and he'll be speaking to us about some of the political battles we are witnessing and the likely implications in the current political space that we are in. But before we get into that conversation, Anne Kananu Mwenda will be vetted as Deputy Governor of Nairobi this Friday. Anne Kananu, who was nominated by ousted Nairobi Governor Mike Mbuvi Sonko early last year, will appear before the County Assembly's vetting committee. Human rights activist Okia Omtata has also filed a case in court seeking to stop the vetting, arguing that Kananu did not assume office after her nomination. Speaking yesterday at City Hall, Deputy Speaker Geoffrey Majiwa said that the stage had already been set for the process. Let's take a look at some of their sentiments.
I am not aware of any withdrawal because up to when he was impeached, we did not see any letter. Any communication from him after impeachment to us is immaterial. We have commenced our process and we will be going on with the vetting as is required of us. So anybody who is giving any statements outside there, we are not party to those statements. Our work is clearly cut out in the Constitution and we do not need advices from them on how and when to do our job. Most of them who are addressing the County Assembly in the streets of Nairobi belong to outside counties.
Well, it is this particular vetting that has opened up a barrage of petitions currently before the court. A number of people seeking to stop the vetting of Anne Kananu for the position of Deputy Governor. But the County Assembly has gone ahead and said they will not be intimidated. That process will not be interfered with, and they will go ahead and do it. So let's speak to some of the legal minds that we have on our panel on this episode of The Front Row. Gentlemen, thank you for joining us. This past few months, Nairobi has been on the spotlight. Petitions upon petitions. We've seen a determination just a few hours ago on Mike Sonko's petition. The court has refused to stop that particular vetting process. But there are other cases that are still in court pertaining to this. Where do we go from here? I'll start with you, George Kithi. You are aware of some of the cases that are in court. What is happening? Talk to us about the huge litigation or massive litigation we are seeing around this.
Thanks. What's before court is several petitions that have been filed, generating into the attraction as to a facet of issues, many issues that need to be decided, but more importantly, what's being prayed for before court. Number one is whether Kananu is legible or eligible to be vetted in the first instance, and thereafter to occupy the position of a deputy governor. But a foremost, of course, is the impeachment in the petition or petitions of the decision by Senate to impeach Governor Sonko, the sanctity or procedure of both substantive and procedural law attendant to the entire process leading to the impeachment, the constitutional issues emerging there too. But more importantly also is how the position of the gubernatorial position is going to be handled in terms of whether we're going for the election itself, whether it is going to be to go through the process of the deputy governor and then she ascends into the substantive position of governor, and more importantly also is whether then the position of governor is vacant as at now, or because there is attendant litigation, it cannot be filled until that process is completed. Now, what is important to note is that
just to cut you short for a bit, let me just cut you short for a bit, that all these petitions touch on the same thing and the kind of interest so we have seen in Nairobi and the process and the politics of it all. What does this speak to?
Now, the interests are various. One is, of course, the rights of Governor Sonko, or former governor, if I have to put it that way, on whether or not he was properly impeached right from the processes of the Assembly and the Senate. The second one is there's also Kananu, who is battling, of course, appointed by Governor Sonko. Governor Sonko's position before court is that he revoked Kananu's appointment, having already gazetted her towards vetting by the Assembly, whether that revocation crystallized or did not crystallize. Then there is also the position of political parties that had nominated certain candidates for purposes of that competitive elective the elections that were due pursuant to the gazettement by IEBC. Whether IEBC correctly gazetted that, of course, is an issue before court. The other issues also would be interested parties who are citizens and members of the public who would want also that issue settled, especially those from Nairobi. And therefore, it is, yes, the questions, of course, congregate, that but the interests are varied in that context. But again, I think what supplements everything is the fact that there was an impeachment that's been questioned up to now, and whether we preserve we continue to preserve that position of the governor,
right,
or that there is also a speaker who is the acting governor right now, and whether he's legitimately holding that position.
Okay, and you've mentioned some of the processes and whether IEBC comes in. Political parties are already flexing muscles, nominating various persons as perhaps they prepare for a by-election. Glad that we have Professor Ajakoya here, because you lead a party that has also nominated someone to vie for the position of governor in the Nairobi County. But the big question then comes that IEBC seemingly continues with this process, even with a court injunction. How are we looking at this? Professor.
Is that for me?
Yes, Professor.
Thank you very much for reuniting me with my friend George Gidi. and my former alumni in Mumias Boys, Mr. Bigambo. Before I proceed, I would like to bring to your attention that Kenya is a land of bizarre occurrences in terms of legalities, where conversion of illegalities through a medium of certain political mindsets in the assembly, they are trying to convert an illegality into legality. And I wonder what kind of school of thought they have gone to. I'm not being clever on this, but I'm telling them right on the face. First and foremost, the power to validate Chapter 6 are embroidered only in the EACC. The EACC has the political mandate and the legal mandate to vet anyone for Chapter 6. That is number one. Number two, the conversion of illegality into legality by bizarre occurrences of where one of the people who is actually in the middle of the whole thing is said not to qualify to be a governor. We are told he has been sworn in and he doesn't meet the requirements of Chapter 6. That is having a degree from a recognized institution to step in the shoes of the governor. Somebody has to explain that. Number three, when you look at another format of bizarre occurrences, you will find out that the IEBC is not aware, apart from reading on the newspapers on what is going on. It has not been served by any court order to stop any kind of occurrences, which also makes it a bizarre occurrence. Now, if we move further, you'll find out that even yesterday, they cleared or they accepted the direct nomination of one Isaac Chege Njuguna to run on the Roots Party. That's another bizarre occurrence. But for the sake of IEBC, they are actually following the laws to the order. Now, how can we, in this particular case, and I'm speaking on behalf of those who never went to law school, how can we fill in the gaps of a governor by the deputy speaker when there is the so-called speaker to be vetted? It has never happened even in New York, where we have got city elections, where we have got gubernatorial elections. It has never happened in the city of London, where we have a mayor. It's only in Kenya where we have bizarre constitutionalism of constitutionalism. And as such, this is going to open up a debate where legal scholars are going to debate on this debate, where scientific evidence is required to ascertain this debate. And as you look into the Constitution, particularly Article 189, 81, read together with 149, it gives the procedures of how to go about in appointment of both the governor and the deputy governor. And if you look in Governor Wambora's case, the Supreme Court decision gave an advisory opinion. Okay. People seem not to have read this. Thank you.
All right. And we'll get into all that nitty-gritties. I want to bring in Javas Bigambo. You speak a lot on political goings-on, and Professor Jacob seemingly calls it bizarre occurrences and conversion of illegalities into legalities. But this whole confusion, as we are seeing here in Nairobi, from where you sit, is it by default or by design?
Well, thank you, Akisa. Factually speaking, tying my thoughts to what Professor Jacob said, reality is that we are in a political legal sea in which we are swimming, and not really swimming to our salvation, but swimming into the abyss of the sea that is both political or politically driven, and then the legal question that are really choking us. The water is rising to our neck level. When you look at the manner in which the Senate conducted its business, and here I'm not questioning the real conduct of or the procedure in which Sonko was hounded out of office, but you realize that Sonko rushing to court over his ouster as governor of Nairobi is because he appreciates that he has got certain legal rights that the court needs to try properly and determine. These issues that are happening in Nairobi County right now are politically instigated. The political motive behind this ouster and all the confusion that seems to be unraveling day after day to do with the leadership and the governance of Nairobi County are all tied to matters of political interests, cutthroat competition, the issues related as well to the Uhuru succession battle, and the powers that drive the politics of various political parties that are the ones that are behind all this. When you see, for example, and my two learned seniors have indicated here quite properly, that as IBC is carrying out its legally its mandate, you realize that it has not been served to stop its processes because of Sonko's approach to the courts. The other thing is that the people of Nairobi have a right to service delivery by a county government as provided for in the Constitution, as provided for in the County Government Act. And because of all this, you realize that the people who are holding the short end of the stick are the citizens, the residents of Nairobi. Because one, while we have got the militarism that has been co-opted into the governance of the city, one wonders that if we have to raise critical accountability issues right now, behind the fact that Sonko signed off the transfer of various responsibilities or functions of the county government to the national government that now is being presided over by Major Badi, one wonders that to what extent do we have mechanisms in place under the NMS that citizens can can raise accountability issues regarding their own services. The other thing is this, that political parties now have gone ahead to identify various candidates that would carry their flag going into the Nairobi nomination. There are questions regarding the authority and the power of the acting governor right now, and has been spoken to by my learned senior Githi, as to whether he has got the authority. For example, if the county assembly ends up vetting Anne Mwenda, does the acting governor have the authority and the power to actually now officially have Anne Mwenda as the deputy governor in terms of official appointment? All these legal questions that are arising and the political confusion that is there is bringing to fore one critical issue, that we are still, as a nation, not so sure about the manner in which we want to steer the proper, effective governance, not just of this county government, but also of the country. All right.
And Kithi, you began by outlining some of the petitions and what they cover. But the big question right now, and what a lot of people are poking holes in, is the nomination and supposed revocation of the nomination of Anne Kananu. Just take us through, perhaps, what is the procedure of revoking a nomination? Because some lawyers on one hand say the right procedure was followed, others say Sonko did right to revoke this nomination but did not degazette it. So what's the procedure that should have been followed?
Thank you. It's a question that touches on some of the issues that are before court for determination. So as we speak generally, we'll put that in mind. When Governor Sonko appointed Kananu by way of a letter, he did so by informing her and promulgating that act through gazettement, so that then publicly that issue would be before the knowledge of the public, and more importantly, inform the Speaker of the Assembly for purposes of then putting forth the procedure upon which the vetting can be executed and eventually appointment can crystallize. Now, remember, once you do that, some rights crystallize on part of Kananu for purposes of the legitimate expectation and Article 47 on fair administrative action, because she must be treated within the confines and expectations of law. But again, there is an emerging evidential aspect that Governor Sonko prescribes that he revoked that appointment, and there is a crystallized evidential element to that extent, which is arguable before court. The procedure for that revocation would follow annulment of the same process that he had adopted earlier. The question that I think would be available for consideration before court is whether the information passed to Kananu, which seems to have been passed to her, but then not transmitted or transmitted to the Speaker of the Assembly, or in the alternative, to the institutions that then had already crystallized in terms of midwifing and commencing processes towards vetting her, but more importantly, promulgating the same position to the public, is arguable. Now, the court then will be called upon to try and distinctly distill the issues of processes of revocation and whether it is enough content of the activities that were done or taken by Governor Sonko towards revocation, and whether the person was informed and whether the public was informed, or whether then the revocation was not, the content and activities leading to the revocation were not good enough, and therefore it still stands that she was appointed. I think that would be interesting to look at it. And more importantly also, as to whether then a sitting governor, having been impeached, the processes that had started and had not even crystallized would still be held and bounded to that process that he had already started. Right. And more importantly further, that if the impeachment crystallized and the Speaker took office as an acting governor without a substantive, and of course because there's no substantive deputy or a deputy governor, will then a deputy governor who is still within the process have the right to be confirmed through a vetting process, right, or has been overtaken by events. So that is probably the cocktail of issues that will be emerging before court.
So, and then of course we wait for the court to pronounce itself on this. But Professor Jacob, a lot of questions right now. One of the big questions in a lot of Kenyans' minds right now, the first petition by Mike Sonko has not sailed through. There are quite a number of other petitions trying to stop this particular vetting process for Anne Kananu. It's about 2 days left to Friday. So what happens in the event that the court or this petition has failed to stop this particular process and Anne Kananu is vetted and approved by the county assembly or the vetting committee? What you say is an illegality that has been converted into a legality. So then it sails through to the county assembly. What happens then?
Thank you very much, Ms. Wandera. And I would also like to echo the sentiment of my colleagues. I would also like to side with Mr. Gidi on what he has said when he used the physiology of things having been overtaken by events. Now, let us go a little bit further or do what we call reverse engineering in developmental stages. Number one, has that governor got the authority, just as what Mr. Bigambo assailed? Does he have the authority? Number two, do we have a lacuna in law whereby the appointment of speakers could also meet Chapter 6 as well as the appointment of governors, since they're likely to step into the shoes of the governor? Do they have to have a degree? Me as a law scholar will say, yes. When you look into the American principles of law, in what we call the Lewisian theories, they assert that for law to be law, as it is written, it must be tested by people who have local standard. We are testing the law whether or not, if that law is law and it's legal, it's only the courts that will come to conclusion. And the fact that you have assailed by saying that if the courts find it favorable for the county assembly to continue on its illegality, then there is room to appeal to the Supreme Court, and that might take time. But one thing that is very clear is who has got a right to oversee Chapter 6? Is it the county assembly, where some of those folks do not even meet the requirement of Chapter 6? Standard 6 kids interviewing a headmaster of a primary school? That's number one. Number two, do they have legal standing to even oversee the requirement of Chapter 6 as enshrined in the Constitution and validated by the legislation of Parliament? Number three, do they know that Article 1 of the Constitution of Kenya comes in with the phraseology of we the people in the preamble, taking away what the IEBC has already declared legal by vacating any other thing other than following what they are supposed to follow, by declaring the seat vacant, and by inviting people who have legitimate expectation in it. What is going to have in that parameter? I wonder, and I'm waiting to see what the judge is going to say, whether that judge is a red light district judge or a green light district judge who validate the law the way it is, or who want to come into judicial activism and look at the law as it was yesterday. There are illegalities.
Okay.
Thank you.
Let me just pick up from something you've pointed out, that there's room to appeal. So we are likely finding ourselves in a situation that will be highly litigious as we go forward. With less than 2 years to a general election, are we likely to see prolonged court battles that will delay this entire process? Professor?
Yes. Songo, first of all, has acted without a deputy for how long? So why are we in a hurry to break the law? Let us wait and see how the law is going to work. But for those men and women in the county assembly who are mediocrity rushing to validate, to pronounce, to take over the role of the EACC, as I have heard one of the, is it the minority leader of the county assembly coming up and saying that they don't really care what people outside there are saying. That means they have got informed opinion. They have already made up their mind. They have already been cajoled with whoever is cajoling these people. Sooner or later, Kenyans are going to say yes, and it's a learning process. Kenyans are going to say, look, is this the mediocrity we have been looking for? Change is going to come in, and let us transform this transformation into reality and follow the rule of law. Let's not do what happened in America, where some lunatics went into Congress to try to overturn the authority. That's exactly what's happening with the county assembly. Thank you.
So let's take as long as it takes, but follow the law, Javas. So in the event this prolongs, and there are all these legal issues, and likely that these battles will go to higher ground as far as the court process is concerned. You started by saying the person or the people who have the short end of the stick are the citizens of Nairobi County. So in the event these battles prolong, and we know there's a lot of politicization of it at the end of the day, what are we likely to see in terms of first governance structures and how the whole devolution aspect is working out for the people of Nairobi? What are we likely to see?
Well, thank you, Kisa. A couple of issues are coming to the surface. First, there is the question of separation of powers. The Constitution contemplates that in the absence of a governor, for instance, who has been impeached, as Sonko has, and in the absence of a deputy governor or who is incapacitated, then the Speaker of the County Assembly will be sworn in for a period of 60 days as acting governor, pending elections of the substantive governor. The law does not contemplate an extension of that period beyond 60 days. Now, when you look at the issue of separation of powers, as I raised it, the Speaker presides over the Assembly, that's the legislature at the county level. The Governor represents and presides over the executive at the county level. When Speaker Mutura presides over the vetting process of the Anne Mwenda Kananu, and then the same Speaker, who is the head of the legislature at the county level, again goes ahead to appoint Anne Kananu as deputy governor. If, and in the event that this is prolonged beyond the 60 days as anticipated by the law, what is it that Speaker Mutura is capable of doing and what is he not capable of doing? Because when you look at the provisions of the Supreme Law of the land, provides for limited powers of a deputy governor who assents, and when, say, for example, the deputy governor becomes governor, then has got full powers. But the law does not provide for the powers of a county assembly speaker acting as governor. And in this case, as it is feared, extended beyond the 60-day period that the law provides for. So the conundrum here that is both political and legal is that the challenge of separation of powers comes in, that the same speaker who will be presiding over debates and discussions about bills in the county assembly goes ahead again to assent those bills into county laws. The law does not contemplate that. So that is one challenge that we have. The other thing, when it comes to matters budget making process, as now the process is going to start again for the next financial year. What roles and how will Speaker Mutura separate these roles, given that, and if the politicians, cunning as they are, scheming as they are trying to, make sure that Speaker Mutura then holds on to the powers as acting governor for a period beyond the 60-day that
we only confine it to...
So the citizen...
Yes, does it really only confine it to 60 days, given the kind of... And I think I'd like this particular interpretation from the three of you, because there's been a lot that has been said when you look at Article 182.6, that the acting governor will remain in office until when a newly elected governor assumes office. I mean, clear that up for us.
The first provision is that the Speaker's acting governor will hold office for 60 days. That's the first provision of law. And that holding that office until, this 60 days is when the election is supposed to be held for the new governor. Then the law anticipates that after that 60-day period, then the new governor will have been elected and then will assume office officially as governor. So the Speaker, beyond the 60-day period, will hold on to the mandate of acting governor until then the new governor or the elected governor, the governor-elect, is sworn into office and then assumes the powers. But the law, by that provision, does not contemplate that the acting governor can hold that office perpetually, in this case until the next general election, which is 2022 August.
Right. Professor Jacob, I'd like your thoughts on this. So then what happens once the 60 days have elapsed?
The courts are there when you got the separation of powers to arbitrate on any legality or illegality or even give the opinion. The courts can extend if there is necessity and for purposes of equity in law. There is no law that is beyond some kind of assumptions. If the matter is there and they're ripe, the issue of 6 days will not arise. The court can extend it. Thank you.
Judge Kithi, for you, kindly just interpret this for us. In the event the 60 days elapse, because there have been a lot of interpretations around this, even as you look at the specific articles and those that you need to read together, even with the County Government Act. What do we do when that happens? Where does this leave the capital?
I think there shouldn't be that confusion. per se, because one, what must be clear is that the 60 days are tied with the 60 days Gazette notice by IBC, within which the reconstruction of the city through the electioneering period ought to have taken place. However, what happened in the instant case is that the Gazette notice that prescribes the 60 days term that was ending in February has been suspended by court, meaning that there can be election within the prescribed period of 60 days as contemplated in that Gazette notice. But then what it has done, it has also frozen time from running. Now, that suspension takes care of the worries as to whether then, after the 60 days, there will be a functionally illegality in terms of the constitution of the executive of Nairobi County. Because of that situation, further, the determination of whether or not the speaker on the 60th day of that Gazette notice or the day he was sworn in, prescribing the running of 60 days, becomes tied or is tied with the days that will have run until the last day when a new governor would have been sworn in. Yes. So because of the suspension by court through an order that the Gazette notice stops to run, the period has stopped, and therefore the office of the governor, pursuant to the occupation of that position by the speaker, continues to subsist until the day that the 60 days prescribed will have determined, meaning the court lifts the order by whatever means, maybe after hearing the matter, and then the 60 days run and culminating into election if we go that way. If then we don't go that way, meaning that Governor Sonko is returned to the office, then of course that determines the term. However, what is important to note is that the day the deputy governor is sworn in, if it goes that way, then the speaker stops continuing holding that office. Let me be clear about this, that if Kananu is sworn in, is vetted and sworn in as deputy governor, then that determines the continued occupation of the acting speaker, on account of the fact that the executive of the county has now been, is now occupied by the deputy governor in part. What would be lacking with the substantive occupation by the governor on account of the fact that there are still pending court processes. So there are all those facets that then emerge within this whole cocktail.
All right, you've really cleared that up. But so then, between now and when perhaps in the event there's a deputy governor, what can the acting governor do? What can he do? Does he have the full responsibilities of a sitting governor? There's a lot of confusion around that currently.
He doesn't have full responsibilities of the sitting of a substantive governor. His is transitional, and therefore the powers, all the powers, let me put it that way, have been taken away, save for the powers allocated in law. For instance, by court, by order of court, the court gave leave to commit the revolving expenditure, for instance, on salaries and running the city. Those have been allowed specifically by court. Remember that there are antecedent issues in this matter. There was the issue of the budget. That issue of the budget was resolved by the court earlier, when the court allowed certain issues to be committed, the funds to be committed at first, and then there was the impeachment, and therefore there was the interim occupation of the office by the acting governor, who is also the speaker. Now, what is important to note here, and the take home would be that this is a process that is also supervised by court, but also there's application of law. The court continues to review these issues from time to time. So those issues that the court has said can be committed and engaged by the deputy governor, either expanded or restricted to what the law says, based on the circumstances prevailing at every instant, are the ones that would be allowed of the deputy governor, or of the acting governor, sorry, and the speaker to commit himself to. So there are very limited powers. For instance, he can't even sign bills into law, obviously, because he's a speaker, has, of course, occupied the office of speaker and taken or participated in making the laws, and then can't come back to be the one who is signing for the interim period on account of the conflict that emerging, the obvious conflict that emerges there. So yes, there are very limited powers that the acting governor would be able to apply himself to and commit the.
All right, and I'd also like to hear Professor Jacoba's interpretation of this on the powers that the acting governor has currently. You started by mentioning the issue of qualifications and whether there's a lacuna on a number of these issues. But then just today, a court has pronounced itself stopping, from not stopping Sonko. Sonko asked to stop that, the acting governor from appointing, reappointing, and dismissing anybody in the county or the county officials. So then when we talk about this sitting governor, this sitting acting governor, until when perhaps a deputy governor or a governor is elected, what happens to the people that this person has appointed, reappointed, or dismissed? How do you look at that, Professor?
First of all, if you follow law too rigidly, then the whole world will break. Law has to be looked into in the following manner. Who makes the law and on whose purpose is the law made? And if you go into different schools of thoughts about the sectarian views on the philosophy of law, you'll find out that there is a lot of closures that needs to be looked into. The question I will start by what I said first, converting illegalities into legalities in a bizarre occurrence. The question I want to pose before my fellow colleagues on the panel is this particular speaker able to be a governor to start with? Does he have the qualifications of a governor, required of a governor? Does he have a degree? If the answer is yes, then I can comment. But if the answer is no, then I do not want to prolong an illegality into a discussion of illegality. Because I can see that whatever is going on leads to what we call restraints. Restraints of my speech. Restraint of the speech. I would not want to speak on something that I'm not very sure of. Mr. Kithi, you're my senior counsel here in Kenya, of course. You represent Sonko, and we cannot discuss on matters which are before the court. But through your knowledge, and maybe you can educate us in this panel, though I'm deviating a little bit. Does this current speaker in Nairobi have a degree? Number two, does the so-called person to be vetted have a degree? Number three, does the county assembly have the validation to vet Chapter 6 occurrences? Since when did this happen? I've seen what they put on their advertisement through the speaker, that the prospective vetee should come in with the following documentation, which are under Chapter 6, which is a prerogative of the EACC. Now, how do you bring a Standard 6 kid to vet a principal of a primary school? How do you bring a secondary school kid to vet the principal of a secondary school? This is a bizarre occurrence. Do they have the validation, the ability in law to even ask or require a candidate to bring in Chapter 6 documentation? Do they really know what that means? Do they have an anchor in law to do that? I raised my case at that time.
Well, we will have Professor Kithi give us the education you asked for on this, but I would like us to take a quick break, even as we mull over that. And when we get back, unfortunately for us, we can go through all the legalists on this issue, but this is a political process. So what kind of interests are there in this high-stakes process? We're getting back with that. Remember, you can join us via slido.com. We'd love to hear your comments on some of the issues that we have conversed so far. What are your thoughts on how the issues around Nairobi are currently panning out in the public eye? You can as well tweet us at Akisa Wandera at KTN News KE. The hashtag to use is a front row. A very interesting conversation, both legal and political, we're having here. So we'd love to hear your thoughts as well. This is your show, so do start texting and tweeting. Remember, you can also text us on 22155. Let's take a quick break. We'll be back with more. You're watching The Front Row.